Thank you for joining us today for this webinar episode, Preparing for Mediation from Selection to Presentation of Claims. My name is Jeff Zano, and I'm your moderator today. This webinar is part of the Financial Poise Alternative Dispute Resolution webinar series. Slide 8 provides a summary of the series, and slide 7 summarizes the episode. And I'll quickly show you guys that, the audience. I think it's right here. There it is. This is the summary on slide 8, and then this summarizes this episode on slide 7. Speaking of the slides, you should understand from the get-go that we may not step through the PowerPoint in order, nor will we have you listen to us read every slide. This is a webinar. This webinar, like all Financial Poise webinars, is a conversation amongst the panelists here today. Keep the PowerPoint handy, however, because I will try to indicate from time to time what slides our conversation is touching on as we proceed, so you can take notes. Slide 5, and I'll do that right now. Slide 5, right here. Slide 5 is our disclaimer. Please note that our PowerPoint is for informational purposes only. It should not be considered legal, financial, or other professional advice. Okay, now I have the honor, and I got to find the slide here. Okay, here it is, meet our faculty. Our honor of introducing our panelists and faculty. We have Leslie Burkhoff of Mort, Hock, and Hamroff, LLP. Leslie is a partner with the firm where she serves as chair of the firm's dispute resolution practice group and is the former co-chair of the firm's creditors' rights and restructuring department. Also joining us on the panel today is Elizabeth Champnoy, Liz Champnoy of Champnoy Dispute Resolution and Management Services, Inc. I used to work with Liz for many years at the AAA ICDR. Liz is an attorney, consulting expert, independent full mediator, arbitrator, and trainer based in New York City with 25 years of experience in the field of alternative dispute resolution. And then we have Byung-Suk See of Snell and Wilmer of Denver. Byung-Suk is a business litigator who represents individual clients in complex intellectual property and commercial matters, and his clients have sought his guidance in dispute related to field business ventures and disputes among business partners, shareholders, and directors. And like I said before, and Michael introduced me, and my name again is Jeff Zano. I am the Vice President of the American Arbitration Association Commercial Division based in New York City. I'm also an attorney. So feel free to read more about all of us, especially the esteemed panelists here. Slides 33 through 37, and very nice pictures of the panelists. This webinar is a production of Financial Poise. To sign up for their great free weekly newsletters, please go to Financial Poise, one word, financialpoise.com/subscribe/. Again, financialpoise.com/subscribe/. If you are attending the live premiere of this webinar, you can submit questions using our web portal. If you are watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question in the name of the webinar episodes, and we will do our best to get you an answer. Okay, now I got to move to our, hold on one second. We would like to thank our co-producer, the National Law Review, a premier legal website. The National Law Review has been around since 1888 on slide 3 that you're seeing right now. Okay, we'd also like to thank our sponsor of today's webinar on slide 4, Maxesset. Am I pronouncing that right, guys? Maxesset? Restructuring and Insolvency Professionals. Okay, let's get started. Okay, turn to slide 11. I'll turn to that right now. Okay, and what is mediation? Slide 11 covers that. And Byung-Suk, I will turn it over to you.
Thank you, Jeff. I think everybody who's participating in this webinar knows what litigation is. They've seen it on TV. Even if you're not a lawyer, you're a business person. You have the judge, the court, and the goal of litigation is to determine fault or liability on one party. Generally, there are exceptions to that rule, but that's not really relevant for this discussion. But mediation is an alternative to participating in the litigation process, which can be used in conjunction with litigation. And basically, the mediation is not designed to seek out fault, to determine who owes who what. There's no judgment, there's no judge, there's no jury. The whole goal is to find a resolution. Now, the mediation is rarely mandatory unless there is some, so there's got to be some agreement amongst the parties that are disputing to participate in mediation. But the goal of mediation is to essentially say, we understand what litigation is. It can be costly, expensive, and there's risks to litigation. So let's shift it to a hope of reaching a resolution, and ideally short of spending the amount of fees and costs associated with the litigation. And the difference between mediation and arbitration, it's kind of, arbitration is akin to litigation. The difference between litigation and arbitration is that you're essentially seeking a private person to determine the results of the dispute. So instead of a judge or a jury, it's typically either one arbitrator or a panel, typically around three, deciding, okay, Jeff is suing Leslie, and in this arbitration, basically we find so and so liable, and there, so you get a judgment called an arbitration award. Again, mediation can avoid that. What's the difference between arbitration and litigation is that, unlike litigation, where when you lose at the trial level, you can seek an appeal. You can do the same in arbitration, but only under limited circumstances, and the possibility of finding any success on appeal is very remote. So you're kind of shortcutting the time it takes to get a final resolution because you're avoiding most appellate issues. For again, mediation avoids that cost because that's still costly, because you're, unlike a litigation, you're paying for the arbitrator's time, which is typically an hourly approach after a deposit. So it's almost like you're retaining not only your own attorney, but another attorney to essentially decide the issue for you. Now, you have to have an agreement to arbitrate. Arbitration is not mandatory. So like mediation, the parties have to agree to arbitrate. Now, that can be done pre-dispute, meaning if I enter an agreement with Jeff, maybe our contract says, to the extent there's a disagreement between us, we agree to avoid courts and go to arbitration. Similarly, that you can have a provision then after saying, even if we are in arbitration or mediation, or we're anticipating that in the future, let's try to mediate first. And if we can't resolve we can't reach a settlement agreement without a third party's involvement, the mediator serves in that role to try to facilitate a resolution.
Quick question. Do you see confusion in the legal field sometimes about the differences between mediation and arbitration with experienced litigators? I sometimes see it. And also, do you see, the second question, do you see some arbitrators that actually think that they're good mediators when, being a great arbitrator doesn't mean you're going to be a good mediator?
Well, let me handle the latter first.
Yeah.
I have run into arbitrators who think they are good mediators, but that's, to me, in my experience, it's not uncommon to see judges also think they could find a resolution for parties and suggest, without any encouragement, hey, you guys should settle, and here's some terms you should consider, because if you go to trial with me, somebody's going to be hurting. I get the similar approach from some arbitrators. But for seasoned litigators, I don't find too much confusion between mediation and arbitration. What I do find though is even amongst seasoned litigators, is that they think it's all or nothing. Either you got to arbitrate or you got to mediate. And I've never been of that opinion. And I think that kind of does your client a disservice if you're always saying, okay, if we don't mediate, we're just going to arbitrate. You can always come back to that mediation kind of option throughout the course of litigation.
Now, we're hearing a lot of debate in New York now, and probably elsewhere in the country, about mead-arb, arb-mead. Would you ever use the same person?
I think I'm going to make my hot take is going to be a little different than probably Leslie and Liz, but I have done it in the past. I think generally the answer is going to be they don't recommend it.
Mm-hmm.
If I can just chime in for a second. And Jeff, this is I have strong views on this.
I know
I know people do this. My view of the universe is this: if I start as an arbitrator and people want me to become a mediator, I'm okay with that. I will not go back to being the arbitrator. If you choose to pivot and start one way and then let the curtain down, so to speak, there's no going back. Even if the parties sign releases, I'm not comfortable with it. And at that point, I would say to them, once you've had me move to that process, you've got to pick another arbitrator if you change your mind. Okay.
Absolutely.
And I don't think you can go from mediation to arbitration. Again,
Okay.
there's very definitive information you get between the two. And so I only see one way that I would ever utilize that. The parties are free to continue. They just need to pick someone
Sure.
else. That's
Different
my
person.
view. Liz may have a different
Liz,
one.
yeah, Liz, you want to chime in?
Jeff, yeah, I wanted to chime in on your original question, or do people sometimes confuse mediation with arbitration? And Beyonce is right. Experienced litigators don't, but one thing experienced litigators do is they sometimes forget that the mediator is not making a decision, right? An arbitrator makes a decision. A mediator is not making a decision at the end of the day. The mediator is facilitating that conversation, the settlement, and so forth. So a lot of times I'll see advocates make the mistake of trying to prove their case to me as the mediator. And I'm always saying, you don't have to convince me of anything, right? I'm here to help you get to a resolution. So that's where sometimes the confusion comes in. On your second question about, what was your second question? I totally just lost it in my brain. I had No, I wasn't going to the meet arb. I was going to, arbitrators as mediators, kind of goes to meet arb.
Yeah.
Very different skill sets, right? A
Oh, God,
mediator
yes.
has to have incredible patience. A mediator can insert themselves. A mediator has to be aware of everything sort of that's going on. Very different skill set than serving as an arbitrator, just listening, taking it all in. A mediator's job is really to move the process in different ways. So very different skill sets. So not all, I want to correct something. You said I've got to get an updated bio. I say this every time we do this program. I want everybody on the call to know that I'm a full-time mediator. I've been a full-time mediator for almost 10 years now. That's all I really do. I do very little arbitration. So my perspective comes from the mediator perspective. But often when I'm asked to serve as an arbitrator, I don't feel the same about it, right? Totally different skill set. I'd rather stick to what I know and what I'm really good at. And I think some arbitrators and mediators need to pick that lane too to do the best.
Full disclaimer for the audience. I see Liz walking around my office in Midtown Manhattan, doing a lot of mediation skillfully. I see you here late at night, early in the morning. So Liz, we're going to stay with you. Okay. So now, is mediation appropriate for you? We can cover this topic.
So I want to go back to some of the fundamentals, which we haven't talked about yet, which are the benefits of the mediation process. Because determining whether mediation is appropriate for you really depends on the benefits and if these things matter. So first and foremost, we know that mediation saves time and money, right? Litigation, very expensive. Beyonce talked about litigation, takes a lot of time, costs a lot of money. So by coming to a resolution early, you can save time and money. So if that's important to you, you probably want to think about mediation. Another thing that mediation provides is the opportunity to have control and certainty in the outcome, right? When we're in arbitration or in court, somebody else decides, an arbitrator or arbitrators, a judge, a jury. So we have no control and certainty in the arbitration process over the outcome, and we have none in the litigation process. So if you want control and certainty, you use, mediation by coming to a solution together. Another benefit of mediation is that you can have creative solutions, right? Courts, juries, arbitrators, limited in the outcomes they can provide based on what the law allows. So having the ability to have creative solutions is another benefit. And then finally, the opportunity to be heard, to have a safe space, a judgment-free zone to speak freely. Often when I give my opening remarks at a mediation, I say, a safe space, judgment-free zone. What you say today will not be used against you. Whereas we know in our judicial system and in arbitration or in court, everything you say can and will be used against you. I often say in our personal lives, everything we say can and will be used against us. So those are some of the benefits of mediation. You can speak freely, not have it used against you. So in determining whether mediation is appropriate for you, those are things I think that counsel often consider and parties. Before I open it up to others, I just want to mention Beyonce and going to what our slide said, there is a lot of mandatory quote unquote mediation going on through the courts. I don't think it's appropriate because, you have to mediate, you should choose to be there. You have to want to be there. It should be a voluntary process. Like mandatory mediation to me just is sort of an oxymoron. That said, there is a lot of mandatory mediation out there through the courts. So sometimes you will be compelled to go to mediation by a court and you'll have really no choice. And then other times you'll have an agreement in place that says, you know, before you file an arbitration or before you go to court, the parties have to attempt mediation. So those are some ways. Oftentimes, though, people just agree to come to mediation, pre-suit, pre-arbitration. Somebody sends a demand letter, the other side says you want to get together. And so you can come to mediation either through court order, just agreement. There could be an agreement that requires you to go, but it should really be a voluntary process if it's going to be effective. You shouldn't be compelled to go there. I know Beyonce, Leslie, Jeff, you probably have other things to add on that topic before we move on. So that's
Well,
what
I'll
I'm
defer to the panelists. Beyonce, Leslie?
So the only thing I'll say, and I agree with Liz, you know, in New York, a couple of the courts call this presumptive ADR. It's mandatory. You know, you're going, and it's
Yeah.
and it's across the board. It's in restructuring cases, large cases have it. The only thing I would say is, and let me back up for 1 second. I agree. If someone forces you into mediation, in most circumstances, and quite frankly, in some of the state courts, most of the state courts, they're not even paying the mediators. So nobody has a dog in the fight. I don't agree with that. I can't change the court system on that. But now you've got sometimes well-heeled parties not even paying for the mediation. You're going to not really get a great result. You're just not. The one thing I would say is when you are pushed to mediation because you don't have anything, I would at least suggest the parties to embrace it because you are where you are. You can't change it. You're going. You don't want to end up with a finding of lack of good faith, which I have only once had to call in the 20-something years that I've done this for an egregious circumstance. But at minimum, even if you don't resolve the matter, you should leave a mediation knowing something better about your case, because as Jeff talked about it, or even beyond, so to some extent, it's early neutral evaluation. I mean, you're getting somebody else in there to advise, not to give legal advice, but to comment on your case, to think about the case, to put on data points or touch points. You may know who your witnesses are better. You may have a better trajectory for discovery. And I'm not encouraging you to use it as a litigation tool, because my hope is that in focusing on your case and focusing on your path, you may end up with a way to find a resolution. But if you don't at least do something with it to maybe narrow the issues or embrace the process, you've just wasted all the time. And this is the trend. We are going there no matter what. The courts are going to do this more as they're clogged, as they can't handle the matters.
Sure.
From a volume perspective. And quite frankly, a fair amount of them do get resolved in the right context at the right moment, although I'm tipping ahead my slides. So Beyonce, is there anything you want to add on this?
Yeah, I just wanted to kind of add an anecdote to kind of it kind of lines up with both what you and Liz are saying, which is in Colorado where I practiced when I started practicing 25 years ago, our federal court had a standing order that everybody had to participate in early mediation with the magistrate judge assigned to your case. So it was a med-arb within a mandatory med-arb, basically med litigation. Sorry, not med-arb. With a judge who's going to sit on your discovery issues if you don't resolve the issues quickly. And as you can imagine, the success rate was extremely low. And then the mediator, who happens to be your magistrate judge, would walk away with certain opinions about you. So the court, about at least, I think it's about 15 years ago, anywhere between 10 or 15 years ago, they dropped that standing order. So there's no standing order in the federal court here, but our state courts still, many of the judges still have standing orders saying you're not going to get a trial date unless you certify you participated in some form of ADR to try to resolve this. And so yeah, most courts are doing it. There are courts that aren't doing it, but I think that's rare.
You know, something that's interesting, you guys, I think all of you know that, all of you do know this, at AAA ICDR, we have our rules, our commercial rules, construction, international, refer to mediation, and we call it mandatory mediation, but it's really not mandatory. If one side says no, it's not going to happen. So we know that. So Leslie, I'm going to turn to you now. When should we mediate?
See, there's no necessarily, it's, you know, people would say, is there a perfect point? So, you know, one of the problems I have with the court presumptive process is that it's a little willy-nilly. Some of it's just like you've hit this data point and you're doing it no matter what, or this time frame, and that doesn't really work. So, and I do a lot of cases, especially in the bankruptcy courts and the clawback situations where it's early stage mediation. That means nobody's taken discovery. There hasn't even been an answer filed half the time. Now, one could say that's too soon, but the answer is not necessarily. It depends on what that is. Those tend to be cases which are clawback cases. You know what you got, you know what your client got, you know why they say you got it. And then to some extent, a little bit of information sharing can get you usually enough information in more of the generic cases to get to resolve it, because you don't need a heavy set of additional information. Other cases, it may be when everybody's ready to head post-discovery towards trial. I think it's a case by case. I just don't think that is a one size fits all. And sometimes, because sometimes you get, and I'm just going to pivot to one other point, I do appellate court mediation. That is the most difficult mediation to do. Somebody has already won. They are emboldened. Unless they are honest,
yes.
and I will tell you, I had one, and nobody can ever figure out which one because I do a fair amount of them, where the judge got it wrong. I know the lawyer knew the judge got it wrong, and they're pounding their chest and they're pounding their chest. And I, in private caucus, looked at them and said, "Do you really think that was the right decision? You don't think the appellate court's going to fix this? Stop banging your chest. You're going to get your head handed to you at the appellate level." And they stood firm, and I trailed the case because I was so curious, and exactly what I said was going to happen happened. The appellate court said politely, "Was the judge smoking something? Come on, how could they possibly find this? It was contrary to the law, contrary to the facts. They looked at it all anew." And so, those are really tough cases because, again, somebody really has won. Half the time they've already briefed it. And all the money's out the door. So you don't even have your litigation, risk savings, dollar savings arguments, all the stuff that Liz and I trot out on a regular basis and Björn Suk has heard, those are gone. So those are harder ones. I do think the only other thing I would add to this is a really good time to mediate. Believe it or not, as much as you'd like to get into discovery, because it is more fact-finding and helpful, the more money that is spent, sometimes the harder it is to mediate. So sometimes it's mid-discovery. You've taken the key dep, you've gotten your basic documents, you haven't taken the experts, you haven't taken every ancillary witness, and you haven't thought about putting pen to paper on a dispositive motion. But I think that parties need to consider when, and the problem I have with a lot of the processes is that they don't think about it that way. It just is by rote.
Got it.
I would add in the employment space, a lot of the majority, I would say, are done right after there's a demand letter or somebody files suit or is about to file suit or there's a charge somewhere. And there's always a debate about, is it too early? I don't have information. But like Leslie said, you can get information, you can agree to share certain things. And the reality is that unless you're litigating, you're not going to have every piece of information. So you have to just go in and understand that and know that's, part of the process. But as Leslie's pointing out, you don't want all that information because that comes at a high cost and a lot of time. And I think Leslie's right on point with the fact that I find after people are on the verge of summary judgment, or we've done all of our depots, we've done all of our documents, and now we have summary judgment motions pending, or we're about to go to trial. Those are the harder cases because not only did you spend all this time and money, everybody's dug in, right? Everybody's drinking the Kool-Aid because they have been arguing their points for so long. Very hard to see the other side of it, or hard to see that you could be thinking of it incorrectly. And that's when people start to make, I think, bad decisions by feeling like I'm going to win 100% here, or I'm closer to winning than not. And then they're upset by what happens in an arbitration or a trial. So there's no 100% time, always works. Like Leslie said, you have to, it's not one size fits all, but it's important to keep in mind, earlier the better to gain all the benefits that, I mentioned at the start.
Sure. Björn Suk, they kind of covered a little bit of this, but your opinions on this? Do we have enough information for mediation? How can we get information from the other side before mediation?
Right. And outside of the arbitration or litigation process, where there's some mechanism typically for you to obtain information from the other side, there's no right to information. And so I would encourage all lawyers and their clients to really think about what can we do to make mediation productive? Because sometimes if you go in and you're thinking, I need to know the profits of this company who I believe is using my intellectual property to steal essentially revenue that should have gone that way. To get that profit information, you typically aren't going to get it unless it's voluntarily provided. So some tactics that I think are helpful for litigators who are helping their clients prepare for or obtain information from mediation is set an example to the other side, put in a settlement offer or a demand, and put in a lot of information that would support it. So obviously you're not getting that information through discovery, is information in your possession or out in the public. And then you say, hey, all this information supports that we would likely win for copyright infringement, and we think you would owe this much money, so we make this demand. Then hopefully they make a counter offer or a response with similar approach, and with that, you typically are armed for enough for early mediation if the parties are willing. Otherwise, the only way to get to information is start a lawsuit, start an arbitration, and demand discovery and collect that. But that goes down the track that Liz mentioned, which is typically when you're going down that route, and I've been in that positions multiple times. We try to get that information and to convince the other side they better mediate. We file a dispositive motion whether it's motion to dismiss or motion for summary judgment, and we're hoping that that's motivation for the other side to consider let's reach a resolution before this third party, a court or an arbitrator, decides who wins the money, and it may not be to our favor. Not the ideal situation.
Does it work?
It has worked in some situations,
Yep.
But not. I would say the other way, the other information that's free to you, let's say I'm representing a business that you should offer up. If you're being sued and only the business is being sued and you literally understand your cash flow scenario, I have been in the position, and I've been in the opposite position as well, whereas if a good opposing attorney or you as an attorney will say, listen, I know you want money, but this company is going to go bankrupt if we go to litigation. Here's the cost of litigation. It's in six figures at a minimum. And 3 years later, cash flow is this. And we provide certified financials sometimes. And that's one of the best ways to get early mediation, I believe, because if I get the same from a reliable independent CPA that certifies the books and records, and I look at it, or have my financial expert look at it, and we'll go, yeah, they have some serious issues. Let's find a resolution short of the ideal, home run at trial and collecting. Because even if you go to trial and get a big judgment or go to arbitration, get a big award, if the entity that you've got or the person has to file bankruptcy, in most situations, your judgment isn't worth the paper it's written on.
Sure.
So,
Sure.
yeah.
Good, one comment, Jeff. Good advocates in mediation know there's no reason to hide anything. Sometimes people will say, like, I'm not going to share it. I'm going to wait for is it Perry Mason? I don't know if that's still a thing, but my Perry Mason moment where I'm going to pull out my smoking gun and I'm going to convince the other side. And I often say to advocates, there's no reason to hide anything. One, from your mediator, give your mediator everything so they're best armed, they can help you. But also, the more you share, good advocates say to the other, look, you have something here, you've brought this claim, you think you're going to win, you have text, you have audio, you have emails, what do you have? Like, show it to the other side, persuade them, don't hold back, don't hide it. Better to get it out there if it helps you. Leslie, were you going to jump in?
Yeah, I was going to just add something. I couldn't agree more. And I find that a lot of times I don't want them to see it. Well, let's be clear. If we don't settle, they're getting it.
Right.
Unless you have buried it and it's a privileged communication that doesn't have to be produced, they're going to get it. So sharing it does a couple of things. I mean, look, I get nobody wants to hand over the damning email that hangs their client, and maybe I would feel differently about that. But a lot of times they have stuff that I had one once where I don't know why they waited until, I mean, this was a ridiculously long mediation. It was like 4 PM. And they're like, well, we have this, but we don't really want to share it. And I literally looked at them, and if I could have throttled them, I would have, because because I knew what was going on in the other room. And I'm going, why would you not have shared that with me? Again, just because you share it with me as the mediator, we can decide whether it's right to share with the other side. A lot of times I get information You want to dribble it out. There may be real reasons to share it over the course of a period of time. But I looked at them and I said, if I'd known about this 4 hours ago, we would be 8 miles down the road, because they completely misunderstood the relevance of the document. And it helped settle the case. They just didn't understand it. And the problem is they were afraid to tell me. The idea is, tell me. I don't have to share it. You can tell me, we can talk about pros and cons and then make a decision. Had they done it, I would have told them, let me run across the other side and wave this like this and beat them over the head with it, because I'm going to settle your case with this document. They just didn't get it. And so I always encourage them to be as forthcoming as possible. I don't have to take it to the other side. Go back to what a mediator is. It's a level of early neutral evaluation. We are there to bring experience. You pick us for a reason. We cannot give you legal advice. That is very different. It's very different to say you missed a defense or you didn't advance a claim than it is to say, let's talk about how the Second Circuit views this claim. And by the way, I am completely free, in my view, to be the adversary in the room. And by that, I mean, I can sit with one side and go, they haven't figured out yet that you have a statute of limitations problem because it's not in their papers. And I'm not sharing it, but I'm going to tell you now, they're going to get there. Because telling something negative to the side that's in the room with me is different than my giving legal advice and going, hey, have you raised a statute of limitations defense? They're very different concepts. So again, more information is helpful.
And
Without a
Jeff, I
doubt.
think we covered this slide and maybe the
Yeah, these
next
next
one.
3 slides, I think we covered.
Yeah.
But Liz, before I go to the, actually back to you, but Perry Mason, I think that's way before your time.
It is, but I was trying to think of like, what's the new,
Matlock, we go back to Matlock.
Matlock. Okay.
Matlock,
But
okay, Matlock,
wasn't
okay.
there a new Perry Mason? I think we covered timing as well, Jeff.
Yeah, I think we covered timing.
really
So I think,
advanced.
Liz, we're to you. How do we get to the mediation process?
Yeah.
How do we get it started? We're to you.
So a lot of times people just write to the other side and say, hey, are you interested in mediation? And then you go about picking your mediator. That's the simplest way. Certain organizations, if let's say you have an arbitration provision, like at the AAA, Jeff mentioned there's rules. You can contact your case manager and say, hey, we're thinking about mediation, that sort of thing. I don't know that there's anything else to say. I mean, it's so simplified. It's not like, and it's so informal. It's not like filing for arbitration or filing in court where there's all these rules and things that you have to have in place. It's very simple just to, write to the other side or call them and say, hey, are you interested in trying to get to a resolution? And then going about trying to find your mediator, which I think is our next slide. Anything to add on
It is,
that,
but quick
Beyonce?
question, Liz.
Sure.
Is it in 2025, it's no longer a sign of weakness to propose mediation? Is that true or is that BS?
I believe I say that almost every day in mediation, where somebody will say midday, it's happens almost every day of my life in mediation, which is somebody will say, midway through the day, Liz, they said they wanted to come here, meaning the other side. And I say,
yeah.
It's 2020, whatever. It's no longer a sign of weakness to suggest. Frankly, I think it's bad advocacy and or borderline malpractice if you haven't explored resolution sooner and you're just on that path to arbitrate. But there are some lawyers who do think it's a sign of weakness. And then that's when I say you use other avenues like the AAA, if you have a case pending in arbitration, or it's good to have the court process with the court asking you, and you could say, yeah, I do want it. And then nobody has to know that. You have somebody else calling on your behalf. But it's not, I don't think it is. Beyonce, Leslie, do you think it is?
Yeah, I want to hear your opinion, Beyonce and Leslie.
So Liz, you're not wrong. I do hear that. If I suggest it, I'm weak. I've suggested this. First of all, it's always easier when the court does it to some extent at the right time, or it comes from a third party. But here's another answer that I've used sometimes at the right one to go, is it weak? They think they have a fabulous case. They're hoping that I'm going to educate you not to waste their dollars. It's not weak. Maybe they're coming from a position of power. And I'm paraphrasing. I'm not saying I would say it exactly this way, but there is an answer to that a mediator can give, depending on who's in the room and what's being said. And I think to Liz's point, people are saving legal dollars. People are being responsible to their clients. And clients are saying, how do I not want to spend that much? And that doesn't mean that they're not going to go to the ends of the earth to get a result if you can't get a good deal. But there's a lot of different answers that educated people should be able to talk about and vet.
Sure. Beyonce, your opinion on it?
Yeah, I would say parties or clients have that perception still. So you have to always
Oh,
educate
still.
them.
Okay.
Yeah, I get a lot of clients that say, hey, we should consider settling, but should we make the offer? And I'm like, well, I mean, let's go through mediation. They worry that that's perceived as weakness to us, and I have to educate them. Say, no, early mediation should always be considered by attorneys. So it's more of educating clients. I don't think I've ever perceived an attorney representing a weak position or vice versa because they brought up the subject of exploring mediation, especially
Yep.
experienced commercial litigators. We all know how expensive this is for everybody.
Yep. And when all of us went to law school, there wasn't many ADR programs and they weren't talking about it. But now I think all of us probably speak at law schools. I do quite frequently. And they're talking mediation all the time. So hopefully it's not a sign of weakness in the future. I mean, hopefully we see that. So Liz, I'm turning back to you. What should you expect from the mediation process?
So selecting the mediator is a very important part of this process. And Leslie was talking about some of the court programs before. Some of them are not as effective, or Beyonce, like you were saying, there might have been a time in your practice that, wasn't as effective when you're forced to go to mediation. The mediators are free, they're not as experienced, and so on. So that's what sometimes adds to that. Forcing plus lack of experience, or the mediators, not getting paid. Very important, though, to pick the right mediator, and not every mediator is right for every case. As I mentioned, I do a lot of employment. Somebody contacted me recently and said, how do you feel about a breach of contract? And I said, I used to do commercial litigation, but am I a contract expert? No. But they don't need a contract expert, according to them. They need somebody who's good with the relationships, who can get to the weaknesses, the risks, what this process is going to look like. So it really depends on what you need, and picking the right mediator is really an important part of the process once you've agreed to go to mediation. I think, and some people disagree with this, and I'll open it up if you do. I think subject matter expertise is very important. As I've mentioned a couple times now, I do employment. It's very obvious to me when an advocate doesn't do employment, or when a mediator doesn't do employment, right? Because there's just certain things that we know that come up in every case, or there's certain confidentiality provisions, or there's certain state of the law with non-disparagement based on your state. So subject matter expertise, I think, is generally very important in employment, probably in bankruptcy, Leslie, probably beyond like an IP. Maybe there's general commercial litigators where in general sort of commercial disputes, that subject matter expertise is less important. But if you have an area like employment, like bankruptcy, like IP, where there are real nuanced areas, I think subject matter expertise and experience is key. I think also having experience as a mediator, and I know it's hard to get the experience. Being an advocate in a mediation is very different than being a mediator. A lot of advocates, say, I'm going to retire now and hang my shingle, and they don't know what it's like to sit really in that other role, or they don't realize, the nuances to that. So having somebody who's actually done it and been successful at it, that knows how to run the process, knows how to organize the process, is important. And then also the personality, right? What do you need? Sometimes I get calls on cases where people tell me, hey, Liz, the facts don't matter at all. I'll send you a statement. Don't worry about the facts. Here's what I need from you. I have somebody who's completely unhinged, right? Needs to be heard, needs some therapy, right? Needs you to identify with them, let's say, as a woman, as a professional woman of a certain age. So personality, experience, how you relate. Sometimes people will tell me, I need you because my adversary is impossible. And I know you're good with dealing with impossible people, right? They're going to be so difficult. So personality, what you need, what your client looks like, what your adversary is like, what you need that mediator to do. Is it to tell them with credibility, you have real risk? I don't see it that way. Is it you need them to give the appropriate therapy, identify, empathize? There's so many different things. So thinking about these various areas. Go ahead,
I
Beyonce.
interrupt on that one, Liz.
Please, sure.
With respect to personality, that I think all of you know that we do video vignettes for our mediators, for a lot of them, not all of them. And does that help? I mean, they're a 2-minute video, and I think it does, to see the sort of, but you get as 2 minutes enough to see the personality for your client, for you. What do you think?
I'll go first because everybody's muted. I think I like the videos. If I don't know somebody, I think it gives me a little flavor. But honestly, I think most people are picked based on who you know, right?
You
Like
know
I
already.
see emails all the time. We all see listservs all the time. You know, I need a strong employment mediator, and somebody might say my name, and then 20 people will write back and say, call me, call me. I wouldn't
Got it.
use her for this. I would use her for that. I think it's more, it comes from word of mouth. I think they're helpful, but I think a lot of people say sort of the same things or the right things. People call and interview you sometimes still. People will say, hey, I haven't worked with you. You've been recommended. Can I pick your
Sure.
brain a little bit about your thoughts on the process? I think that's helpful, right, to get a sense. But I think looking at them, and Leslie, we did this recently in a case, just
Yes, we
looking
did.
at them, getting a certain impression based on the video, what they said or didn't. I think it's telling, but it's not the only thing. I think you need a lot more than that.
Right, and I'll just chime in, and I've done them because you guys made me do them. And Jeff, if you want us to talk more than 2 minutes, I'm one of the only people that made it through without flubbing it. And they were so thrilled because they were so far behind that nobody could get through. 2 minutes goes quickly and slowly at the same time to get a lot of information in and not
does.
like an automaton.
I saw your video and you did a great job.
Thank you. He's just lying. That's okay. I think they are more helpful in arbitration than mediation. I agree.
Interesting. I thought the opposite.
No, and I'll tell you why.
Wow.
In my view, and here's what I think. I think most people pick mediators from either historic use in word of mouth and recommendation.
Like Liz, yeah.
Okay.
Exactly.
I
Yep.
really do. A lot, I'd say 80% of my mediations come from word of mouth versus just generic court appointment. And people that I've used before or firms that pick me. I think in arbitration, because it's a larger group and you are the likelihood of, let's say, my firm or Beyond Sook's firm having seen an arbitrator or have experience, it is much harder because your mediator is more likely to be local. Just if you're doing hands-on, it's much more likely to be in your, so you're going to get people. In the case that Liz is referring to, we looked at the arbitrator's videos, and what it helped us do is actually kick people off a list because because for two reasons. One or two people look like, I'm like, oh no, I'm not sitting through that person. You could tell their personality was not what we wanted in the room. And occasionally, this was not a bad thing. It was just how they viewed certain things. They viewed the discovery process a certain way, and we knew what we wanted in the case. And so when they espoused what their view was, I respected it was their view. It wasn't going to work for us.
Yep.
And so it was helpful, and it did help us pick the person that we ended up with in one instance, because we saw them, we got a feeling for them, we got a flavor. They look kind of easy, but so it was a visceral reaction of somebody we were going to live with for weeks on end in a hearing. And I felt that arbitration was more useful, but that's just my view.
Sure. Beyond Sook, your opinion on, have you seen those videos from AAA?
I have not, but we to touch on that, we still, our firm's big enough where we still send out emails saying, hey, here are the arbitrators.
Yep.
And we typically get a good return in the sense that we'll have at least two people that can say, oh, I've worked with Leslie, I've worked with Liz, and here's my input and thoughts on both for your case. But when it comes to mediators,
who do they like better? Do they like Liz or Leslie better?
They like
different areas.
They're both
I'm
freaking
joking.
awesome.
but in any case, what I wanted to add for a factor that I consider more and more these days as a litigator for mediators is personality, because you can find the expertise, you can find the experience, the credentials, and all that. I tell you, based on my and my client's perception of the opposing side and opposing party, I focus on personalities a lot. If I think the other side needs what we describe locally as settlement judges, as mediators, where basically they're strong personality and they tell you, they're expressive about why they think your case is strong and the weakness of the case, we go for that based on pure personality. So all of these factors that we're seeing on the slide is absolutely valid. I just want to say from a litigation perspective, though, lately, it's been personality that I've been focusing on more than anything else.
And
Very
you
interesting.
raise a good point, which we didn't sort of touch on, which is, like you said, you can get the subject matter and so forth, but there are very different styles of mediator, right? So there are
Oh,
people
sure.
who are purely facilitative, where they think their job is to just go back and forth with messages, maybe reframe what you said, maybe have everybody together and speak directly. Then there's more evaluative, where what we've been talking about, I think that's more of what people hire me to do, is to say, look, I don't believe that argument, I think, is your weaker one. Your bigger one is this. I'm really concerned about this for you. They're going to win on this. Like that combined with that back and forth facilitative nature. But you can have people who you might need, like when you're talking about personality, you might need what people always say to me is a strong mediator. I need a strong mediator who's going to basically kick everybody's ass to get to, forgive my French, to get to a resolution, rather than the sort of laissez-faire, okay, what do you think? Well, that's a good point. What do you think? Okay, what do you think? Like that volleying, maybe less effective in commercial, employment, bankruptcy, business type disputes, maybe better in family and or, elder care issues, things like that. Just a thought.
Sure. Liz, before we go to Beyonce, selection process, did you hit that? I think you did or
I
not?
didn't, and I think what we kind of did is terms of people just ask around, right?
Got
I
it.
know AAA will provide a list. I think you still have all the mediators available online, right?
We do.
So you can look into them, but it's different than arbitration, right? In arbitration, and when we get to those in our later series, you get a list, you strike, you rank who you like. In mediation, it's really you're talking to the other side, proposing a couple of names and saying, who do you like better? Okay, let's go with that person.
Got it. Thank you. Beyonce, settlement and mediation.
Yeah. I think you'll find litigators with differing opinions than mine, but I am a strong proponent of at least getting one round of settlement attempts out there before kind of stepping into mediation. And there's two reasons for that. One, there's the potential that actually I may have an attorney on the other side or a party on the side that, even though we may disagree in our legal positions, that we have a good fit in terms of, oh, I think I can work with, Jeff and reach a resolution that's going to work. And I do a lot of business divorces where, private companies basically fighting with internally. Sometimes that you need a good attorney on the other side because the resolution is typically another business transaction, which may be very complicated. So if I all of a sudden, if Jeff, you're on the opposite side with me and I make an offer and your response may not be something that we'll accept, but it gets us the parameters of the discussion that I think, oh, Jeff and I can deal with this. That's great. We didn't even have to go to mediation. But the other the reason that I encourage at least one round of settlement negotiation is I may see where Jeff's counter demand to me may be something that's unacceptable and we're too far apart. However, conceptually, I could see a third party coming in and trying to mold all of us into the right place to deal with this transaction. And it's always good to know before you go into mediation, okay, typically one party offers demands more than the other is willing to pay, and vice versa. So I want to know the range already. I've participated in mediation where I haven't had that round, and the success rate's fairly low because we're usually shocked by the first response on the other side. And we kind of need almost for emotional purposes, my client to understand, hey, that's their highest position, let's see if they're willing to go to mediation. Given our position, we could at least try to, have the mediator work within that band. But if that band is unknown, sometimes the first response from the other side can be shocking. So I very much encourage basically settlement demands or counter demands or responses prior to mediation from one round from both sides. That's what I encourage. Yeah.
Great. Okay. So what should a client do prior to mediation?
Yeah. The client should really be focused on understanding that first of all, they should just be forthright with your attorneys. I've had some clients who, for some reason, thought, "Oh, I'm not going to disclose to Byung-suk what I'm really willing to settle for until I get the mediation." And and it's not gone well typically because as attorneys, I work within the expectations or the kind of the scope of my client wants to go for. So if you tell me you're willing to settle only at you're only willing to settle if the other side pays you $50,000, whereas you're actually willing to take $25,000, I fashion my kind of posture towards that within the limits of the law and the facts, obviously. Okay. So you undermine my credibility if you don't explain your true goals in the case. So I always encourage the clients to be honest with me and to basically tell me what your goals are so I can scope and contour my tactics and strategy. I shouldn't say tactics. I could probably, Leslie and Liz are probably cringing at that phrase, but scope my plan to fit the goals of my client and within the context of proper mediation. And it also helps me to understand, okay, how much do I need to actually work on my own client to manage expectations? Because if you think that you're going to get $1 million when I think that your home run is $50,000, that's a long come to Jesus meeting with me prior to mediation to get you in the right place.
Absolutely.
Yeah.
Okay. What are you willing to walk away with, Byung-suk?
Yeah, that's a discussion that I think you should always have a forthright discussion, and that feeds into what we talked about before. So I always ask my clients, listen, not only, especially if you have an individual client, I often, or a small business client where the principals it's a very flat organization, or I represent a business partner suing another business partner in a company. I always always want to make sure that they give me their full range, like we discussed, but also ask them to consider the soft factors, something you can't quantify, such as much as I enjoy what I do, I recognize some of my clients never want to see me because I'm the equivalent of an oncologist and they never want to see me again. They're only seeing me because they have to. So I let them know, hey, if you're a small business, if we go to trial or if we go to arbitration because we can't reach a settlement and mediation, you're spending a lot of time with me. Not only am I diverting your attention emotionally, from a business perspective, you're distracted because I'm saying, get me these documents and help me walk through your financials. Let me prepare you for your deposition. Let's prepare for trial. Here are the, so it's emotionally taxing for my clients. The only people who really feel good about the process is me. So, we got to always be on the right page with the soft goals as well.
Sure, absolutely. Okay. Leslie, I'm turning back to you. We have a few more minutes.
Yeah, I'm gonna combine a little bit here.
Okay, please.
So here's what I'm gonna say. This is the way I view mediation statements. And by the way, when I get assigned as a mediator, I always have an all hands on call. It's usually just the lawyers, clients are welcome. I will do pre-mediation calls with clients and advocates. And that's some more of this about what we do in our mediation we cover in a later session. So we're not leaving you without other tools. We're leaving you to come back for the next session, folks. But a mediation statement should be this. It is not a legal submission to a court. So when I get a traditional motion style pleading that's advocating a position with no acknowledgement of weaknesses, with no settlement focus in it, with litany of cases that are string cited for pages on end, I know that the litigator hasn't taken off their hat or settlement counsel hasn't come in. And I emphasize to people, the idea is to get me information and get the other side information. So depending on where you are in the case, you may have exchanged a fair amount of information. It may be you already have a motion for summary judgment. Give me that. Stick something on top of it and tell me and acknowledge where it is in the context of the case, where it is with pros and cons and ups and downs and weaknesses, etc. And there's a difference between an exchange statement, which is on our next slide, and you don't have to skip to it, and our confidential. I always want parties to share with each other. but make it settlement focused. The difference is you're trying to convince the other side why this thing should be settled. It is a different tone. It's different information. It's packaged differently. You are missing your mark if you don't do it this way. You're not educating me. And some things you may not want to put in there. You may not want to acknowledge that, yes, they're right. You're dead in the water on this. Put it in my config. Send it just to me. Don't look like an idiot. I'm not stupid. You've hired me. If I think you're dead in the water, I may say it privately to you, but if you don't acknowledge it, I'm going to think you're an idiot. But more importantly, I'm going to question how you're making decisions. And yes, Beyonce would tell you as a litigator, we've all won cases we should have lost and lost cases we should have won. And we don't always know what a court is going to do. But there are certain things that we can look at within a circuit or within a construct. And Liz referred to them earlier. The reason you hire her in employment cases is she's going to be able to tell you that cause of action is just not going to advance. There's no court that's going to grant that. Or yes, the other side has a better argument on X or Y with a risk analysis. So information is key, but not extraneous information. Data dumping, string citing, all useless. Showing the other side you know your case is hugely important. You can only do that if you do a real analysis. Sometimes it's also telling me a couple of other things in the config. That if Bob is not at the mediation for the other side, we're never settling it because Bob is the key person. And if Sally shows up, don't you dare put us in the room because Sally and John hate each other. And maybe you don't want to put that in writing. Maybe you want to communicate that to me orally ahead of time. Letting me know in your confidential at minimum, but if it's been exchanged, there's no reason it shouldn't be in an exchange statement. What was the last bid and ask? If you've already exchanged offers and responses, let me know. I hate going into a mediation and no one's told me, but there's been 3 rounds of offers and I don't know. I'm picking up like in the middle of the play halfway through. That should be said. Also, because quite frankly, on occasion, somebody doesn't realize that it went and it came back or it wasn't responded to. I had one recently, they came in and apparently during the course of the mediation, I found out that a letter had gone out with a different number in it than everybody was talking about. And it caused a lot of consternation because I would have set the table maybe differently.
Sure.
Sometimes you have changes of counsel, so this stuff is helpful. And sometimes the clients may actually look at these documents and therefore having it in there is really, really helpful. But like I said, again, and I'm not a form over substance person, so I'm okay, especially when it comes to the confidential, with someone sending me a lengthy email that shares the data points or at least a basic letter and gets it to me. And so too, don't, if there was an order of the court that got entered, you should be telling me about it. All of this stuff should be out there.
Sure.
And if you don't know how to do a settlement-focused statement, then call a settlement counsel, look about what's out there, because to me, it's a missed opportunity if all you do is take what would have been the motion to the court for summary judgment, scratch it out, say confidential mediation statement for the both parties, and stick a preamble and a closing on it.
Right. Thank you, Leslie. Liz, you're going to close us out. Communication.
Yeah, so I see we're running out of time.
We're almost out of time. Yep.
To sum up this slide, I think the most important takeaway is that unlike a judge, unlike an arbitrator, you can speak one-on-one ex parte with the mediator. So if you're represented by counsel, the mediator doesn't want to speak to you. They want to speak to your counsel with you present, right? But they won't speak to you separately. But if you're not represented, they'll speak to you directly. But I think it's important to know it's not like court where if I called the judge as a lawyer and I didn't have my adversary on the phone, I'd be in a lot of trouble. If I called the arbitrator and I didn't have my adversary on the phone or emailed the arbitrator or emailed the judge without copying my adversary, right? That's inappropriate, unethical, wrong, right? But with mediators, it's not, because remember, the mediator is not making a decision. The mediator is there to facilitate that conversation. So biggest takeaway, you can speak directly to the mediator. And I think we've covered this, which is you should tell the mediator everything. Unless you've picked the wrong mediator or a mediator has been forced upon you that you don't trust, tell the mediator everything. There is nothing to hold back from the mediator. The mediator is there to help you, is your partner, is your, I say sometimes, friend, but the mediator is there to help you. And if you're holding back from the mediator, you're really doing yourself and your client, right, a disservice.
Sure. Well, we're going to touch on this on the next series in May, but quick question before we close out. I'm going to go run yes or no to each of you. Virtual or in person? What do you prefer? Beyonce, what do you prefer? Virtual, in-person mediation?
In person.
In person? Leslie?
In person, if I can get them here.
And Liz, I think I know your answer.
I prefer in person, but I will say this. I have 3 the remainder of this week, all of which are in person, and 5 next week, all in person. So
Oh, wow.
I'm regretting a little bit all in person. I would like a little virtual day in there because, 5 in a row is deadly. 5 in a row in person, I'm not sure I'll survive the week, but I definitely prefer in person. I think there's a greater commitment. I think there's a greater focus. I find they end at a more reasonable time than when we're virtual because people are like, oh, I want to get home, have dinner, I want to get a train. Whereas virtually, people are just, they're comfortable. They don't care as much. So in person,
Okay, actually, I have
regretting it a little.
one final question before I go. Will AI ever affect mediation? Do you think, Beyonce, do you think there'll be an AI mediator?
Oh,
Just a quick
I don't
answer.
think so.
Okay, thank you. Leslie?
Because nothing. Go ahead, Leslie, go ahead.
I was going to say, because the answer is there is some AI out there in certain capacities, and I've written on this, but here's the thing. At the end of the day, mediation is about human emotion and connection, and robots cannot replace that. Make that assessment. As good as they are, you can't replicate us, despite the Terminator and all of those other cases. Or the good movies, I
Great
mean.
movie, great movie. Liz?
Well said. Somebody you and I know well who will not say this. I won't say his name. We always say, are we good at this because, and why are we so used? Why are we good at this? Why are we successful? Is it because we're so intelligent? And I say, it's not because we're so smart on the substance. It's because we're good with the people. And that's what a great mediator is good with the people, the emotion, the feeling. Even when you have true business to business disputes, getting at everybody's underlying interests, what's going to appeal to somebody, what's going to turn somebody off. That's what separates, good from average mediators.
Great. We'll close out with that. Thank you, Liz. This concludes our webinar, and I want to thank Beyonce, Leslie, and Liz. You guys are always terrific, and it was a pleasure working with you. And Leslie, I can't wait to see you tonight on another program.
Yeah, we'll see you in a couple of hours, and
Yeah.
we see both you and Beyonce in New Orleans. For those that
Yes.
are at the ABA Business Law section, come find us. We'll be running hosts of programs and running around, so you can find us there.
Absolutely. So thank you for joining our another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. And we hope you will join us for our next webinar in the Alternative Dispute Resolution series. And it is May 20th. It's number 2 in this series of 4, Conducting the Mediation. The next one is number 3, Preparing for an Arbitration, premieres on June 25th. And then the final one, number 4, Handling the Arbitration, premieres on July 22nd. Again, thank you to our wonderful panelists, and thank you to the audience. Thank you so much.
Thank
Bye,
you.
all.
Have
See you
fun
soon.
tonight and next
Thanks,
week.
guys.
Be well.